Hello everyone, welcome to the 100 Literary and Jury Charge. We're going to start off with some legal words and then I'm going to read you the paragraph. Okay, so let's go over these words. We've got sine qua non, scintilla, ipso facto, and the last one is ignorantia legis non excusat. I'm going to say it again. Ignorantia legis non excusat. I'll spell that for you. IGNORANTIA space legis LEGIS space non NON space excusat EXCUSAT. Okay, so we're going to find out what all of these mean. Here we go. Ready? Ignorantia legis non excusat literally means ignorance of the law is no excuse. A person summoned to court for an illegal act cannot plead ignorantia legis non excusat. Ipso facto means by the very fact itself. In other words, ipso facto means to rely on the facts without any further action by anyone. In the term ignorantia legis non excusat, you may see the word juris used in place of legis. Essential elements and facts of a case are termed sine qua non. Sine qua non evidence is indispensable. The word scintilla means a spark or a particle. Scintilla, when used by attorneys, means a small but material piece of evidence. All right. Got some fun facts here. This is on babies and birth. Okay. All right, here we go. Newborn babies are not blind. Studies have shown that newborns have approximately 20/50 vision and can easily discriminate between degrees of brightness. A fetus in the womb can hear. Tests have shown that fetuses respond to various sounds just as vigorously as they respond to pressures and internal sensations. A survey conducted at Iowa State College suggests that a parent's stress at the time of conception plays a major role in determining a baby's sex. The child tends to be of the same sex as the parent who is under less stress. Statistics based on more than 500,000 births occurring in New York City hospitals between 1948 and 1957 showed a significantly greater number of births taking place during the waning moon than during the waxing moon. Until the 1920s, babies in Finland were delivered in saunas. The heat was thought to help combat infection, and the warm atmosphere was considered pleasing to the infant. Children born in the month of May are on the average 200 grams heavier at birth than children born in any other month. Up to the age of 6, or 7 months, a child can breathe and swallow at the same time. An adult cannot do this. Try it. Dwarfs or little people almost always have normal-sized children, even if both parents are dwarfs or little people. Twins are born less frequently in the eastern part of the world than in the western. Interesting facts. Okay. Moving right into jury instructions. Okay. All right. Here we go. The heirs of Alfred B. Shuster, the deceased, are the real parties of interest in this action. They are Michelle Ray, the widow, and Denise Lee, age 12, Craig Roger, age 10, and Martin Bryan, age 6, the minor children of the deceased. If, under the court's instructions, you find that the plaintiffs are entitled to recover against the defendant, Matrix Systems, Inc., you will award such damages, such a sum of money as will be just compensation for the loss which each of the heirs has suffered by reason of the death of Alfred B. Shuster, the deceased. In determining the amount of such a loss, you may consider the reasonable financial support, if any, which each of the said heirs would have received from the deceased if he had lived, and the right to receive support, if any, which each of said heirs has been deprived of by reason of his premature death. Let me just note that the right of one person to receive support from another person is not destroyed by the fact that the former does not need the support, nor by the fact that the latter has not provided it. You must also consider the following: 1. The age of the deceased and of each of the heirs. 2. The health of the deceased and each heir immediately prior to his death. 3. The relative life expectancy of Alfred Shuster and of each of the heirs. 4. The disposition of the deceased to contribute financially to support each of the said heirs. 5. The earning capacity of the deceased. 6. The habits of investment and thrift of the deceased. And 7. Other facts shown by the evidence that indicate specific benefits each heir might reasonably have been expected to receive from the deceased had he lived out his normal, natural life. In regard to life expectancies, you should only be concerned with the shorter of the two, that of an heir, or that of the decedent. You will award reasonable compensation for the loss of love, for companionship, for comfort, for affection, for solace, or for moral support. In determining the loss which each heir has suffered, you are not to consider the pain or suffering of the decedent, any grief or sorrow of his heirs, or the poverty or relative wealth of any or all of the heirs. Also, you should include in any award an amount that will compensate for reasonable funeral expenses. All right, I have an excerpt from Don't Sweat the Small Stuff. And this is on create patience, practice periods. Here we go. Patience is a quality of heart that can be greatly enhanced with deliberate practice. An effective way that I have found to deepen my own patience is to create actual practice periods. Periods of time that I set up in my mind to practice the art of patience. Life itself becomes a classroom, and the curriculum is patience. You can start with as little as 5 minutes and build up your capacity for patience over time. Start by saying to yourself, okay, for the next 5 minutes, I won't allow myself to be bothered by anything. I'll be patient. What you'll discover is truly amazing. Your intention to be patient, especially if you know it's only for a short while, immediately strengthens your capacity for patience. Patience is one of those special qualities where success feeds on itself. Once you reach little milestones, 5 minutes of successful patience, you'll begin to see that you do indeed have the capacity to be patient, even for longer periods of time. Over time, you may even become a patient person. Since I have young children at home, I have many possibilities to practice the art of patience. For example, on a day when both girls are firing questions at me as I'm trying to make important phone calls, I'll say to myself, now is a great time to be patient. For the next half hour, I'm going to be as patient as possible. See, I've worked hard. I'm up to 30 minutes. All kidding aside, it really works. And it has worked in our family. As I keep my cool and don't allow myself to be annoyed and upset, I can calmly yet firmly direct my children's behavior far more effectively than when I get crazy. The simple act of gearing my mind toward patience allows me to remain in the present moment far more than I would if I were upset thinking about all the times this has happened before and feeling like a martyr. What's more, my patient feelings are often contagious. They rub off on the kids, who then decide on their own that it's no fun to bother Dad. Being patient allows me to keep my perspective. I can remember, even in the midst of a difficult situation, that's what's before me. My present challenge isn't life or death, but simply a minor obstacle that must be dealt with. Without patience, the same scenario can become a major emergency, complete with yelling, frustration, hurt feelings, and high blood pressure. It's really not worth all that. Whether you're needing to deal with children, your boss, or a different person or situation, if you don't want to sweat the small stuff, improving your patience level is a great way to start. Great advice. All right. I have some closing arguments. All right, here we go. Ready? Thank you, Your Honor. I am sure you are all glad we have reached this stage in the case, and at least we are getting a start this afternoon. I want to thank you for your patience and for your attention during the course of this trial. I am sure counsel does as well. It has been a fairly long trial, and we have covered a lot of evidence and a lot of witnesses. I intend to go over some of the things that I think have the most importance to the prosecution's case. I intend to discuss the law and how it relates to the facts of this case. I won't cover everything because I feel a great deal of it is self-explanatory and not necessary for comment at this time. What I say and what Mrs. Delaney says during the course of this argument is not evidence. The evidence is what you heard from the witness stand and the exhibits that you are going to see. If your recollection is different from mine about what was said, go by your recollection and notes and not by mine. There certainly isn't going to be any attempt to mislead you as to what was said during the course of the case. You know it perhaps even better than I do. As I said, and told you in the beginning, in the opening argument, a case like this is much like a puzzle. It is the pieces going together. Different witnesses can view the same thing, and all of them see it a little differently and perceive different things depending upon what they are concentrating on and what is important to them at the time. I think you can see, if you take the testimony of all of the witnesses and put it together, that you do get a fairly comprehensive picture of what happened, specifically on the night of November 28 and on the earlier occasion as well. This case is not really a whodunit type of case. It is more of a decision on your part as to what it is exactly that Mr. Valentine has done, whether or not he is guilty of the crimes that we have charged him. Much of what was presented to you, I am sure, is uncontested by the defense as far as the facts, how they came out. A prime example of this, I think, is the robbery count 2 in the case of November 23 of 2011. Okay, and that concludes our literary and jury charge for the 100 class.